All right. Hello again. This is the fourth part of our discussion of shareholders. Um, and so in this segment, we will discuss stock certificates, preemptive rights, dividends, inspection rights, and the transfer of shares in turn. All right. So, stock is an intangible right, but a couple of states still require that shareholders be granted stock certificates. That is not true in the majority of jurisdictions. They are notional book entries at this point. And that means essentially that the right that attaches to the stock certificate exists separately from the stock certificate itself, even if the jurisdiction requires a stock certificate. So your account, your stock account, is really just a, a bookkeeping entry, right? But it gives you certain rights. So certain other types of rights or authorities that shareholders have. For example, preemptive rights. Sometimes the Articles of Incorporation will grant preemptive rights, which is essentially a preference over outside purchasers to subscribe to additional issues of the company stock. So, in a couple of scenarios, a company can have unissued stock that is authorized, I'll call it authorized but unissued stock, or in fact, they may pass a resolution for the issuance of additional stock. So under those two scenarios, different things would happen, right? In either case, the stock that was no longer, that was not previously circulated is now held by owners, right? And if we're issuing new stock, that's going to dilute my fractional interest, right? But even if they're issuing stock that's been authorized, that's going to that's going to dilute me vote-wise, if not in respect to my profit participation, right? So preemptive rights basically give a preference. They're not mandatory in any jurisdiction of which I'm aware, but they give a preference to existing shareholders over outside shareholders. And they'll apply generally only to newly issued stock and must be exercised within a specified time period, right? So a shareholder who's given preemptive rights can purchase a percentage of the new shares being issued that's equal, sort of a pro rata percentage that's sort of based on the amount of current share ownership and its relationship to the overall share ownership. So that's preemptive rights. Dividends, as we've discussed, is the receipt or the distribution by the company of, and the receipt by the shareholder of profits from the company. On occasion, things other than money can be paid out in the form of dividends. But it represents corporate profits or income. And the payment of dividends is authorized by the directors, much in the same way that the payment of any excess profits would be authorized by the partners, right? So the people who are authorizing the payment and the people who are entitled to the payment are now separate, right? In the case of the corporation, just to keep that in mind. So state laws tend to vary on the payment of dividends because, even though it's declared by the board of directors, it still needs to be in accordance with the requirements of statute, just as with any other area of law. And so with regard to this area, we tend to look to the revised Model Business Code, RMBCA, or RMBC. But the states may have their own specific variations of how they want dividends paid, how often they have to be paid. They may also have controls over what types of revenue may be used. And all states allow dividends to be paid from undistributed net profits, right? And payments may be made in kind sometimes. There's an example in the book of a distillery that paid its dividends in the form of bonded whiskey, which I think is interesting on a couple of levels because they're distributing something at wholesale or retail, I would imagine. That basically cost them, obviously a lower amount. Now, that said, the reason that these state laws exist is that dividends must be paid out in a legal way, in a way that is legal. And if they are not, then they amount to what is known as illegal dividends. And here is an important point. If the payment of the dividends is illegal, the board of directors is personally responsible. Why? Because they've acted outside of the scope of their agency, right? And generally, dividends will be illegal, among other things, right? But most specifically, if they're not paid from proper accounts, or if the payment of the dividend causes the company to become insolvent, because those aren't profits, right? It has to be profits, right? So if the payments would destabilize the company and make it so that the company can't pay its bills as they come due, even if those bills aren't immediately the second due, right? They're coming due next week and you pay the dividend a week before, doesn't change the fact that the payment, even though that bill isn't becoming due, right, yet. But if you're not going to have enough new cash coming in to actually pay that bill, you know it, then the payment becomes illegal, right? Dividends need not be paid when the company is not profitable, right? In fact, they can't be paid when the company is not profitable. However, when the company is profitable, with regard to privately held companies, that's why people own shares of small privately held companies, to receive their dividends. And they take the risk that in an unprofitable year, they will not receive dividends. But if you're in a closely held or a otherwise privately held company, the reason you're holding that share is not for its fungibility. You're holding it because it puts cash back in your pocket periodically, generally at least annually, right? And sometimes not annually, right? But that's, we know that corporations may choose to retain earnings for growth, right? And not distribute all of its, excess profit in the form of dividends, right? They have the responsibility as directors and officers to grow opportunities for the company. So making investments with profits is not in violation of this notion that corporations should pay dividends, right? But at some point, right, if the interests of shareholders are not being regarded, if dividends aren't being paid, if some dividends are not being paid, right, at some point, then the shareholders can actually go to court and compel the payment of dividends. And the directors have to show that they're not withholding the payment of dividends unreasonably, right? The conduct is going to be evaluated under the business judgment rule, and they'll look for an abuse of corporate discretion. And if they find that, then they can require the payment of a dividend, right? But just because you have earnings or a surplus to pay a dividend is not enough to compel the distribution of funds, right? If the board determines that, we need to save earnings because we don't know, there's a big pandemic coming, for example, and it might be a good idea, because, we don't have enough, supplies to prepare for a disaster, right? Companies have to do more than just pay out their profits, right? They also need to remain fit. And if they pay out every penny of their profits in the form of dividends, then they'll be less fed at some point. So it is a matter of judgment. And so, obviously there are weighing tests. This brings us, though, to the fact that if there is an abuse of discretion, right, then all of that, that deference to the board's judgment or to the officer's judgment, or, to the board's judgment, because they would be the ones to declare the dividend. Officers are just executing. But the board's judgment goes out of the window at that point. Which brings us, of course, to the rights of inspection. Shareholders in a corporation have the right to inspect the books of a corp or certain specified records. Let me be clear. Certain specified records are available to shareholders upon request made in advance. And shareholders are entitled to do so in person or to have an agent, such as an attorney or an accountant, do so on their behalf. In some states, to present a fair situation that is not abused by overly speculative people, they require, some states will require a minimum holding period. Like you can't just, I think there's a problem at X corporation, let me go buy a share and then see if I can stir up a derivative lawsuit in the next 30 days, right? Some states will require you to hold shares for a certain amount of time before you exercise this right. But on demand, you have the right to examine certain records. So in one of the examples, Leah is a majority shareholder of Market Mobile Incorporated. She sells the firm's assets to herself and sets up another corporation, Nano Research. Leah then tells Market Mobile's minority shareholders that she is dissolving Market Mobile because it is failing financially. Kurt, a minority shareholder, asked to inspect the corporate records so that he can determine Market Mobile's financial condition, the value of its stock, and whether any misconduct has occurred. Kurt has expressed a proper purpose for the inspection and must be allowed access to Market Mobile's records, even if they only have one share, right? And so that should be kept in mind because one of our prompts this week, I think, addresses that, at least in part. The power of inspection is fraught for abuse. That's part of the reason that in some states they will place a limitation, a minimum, like a minimum, like you must own shares for X number of months or days. But proper purpose is subject to the discretion on some level. Until it's challenged in court, it's subject to the discretion of the company, right? And so a corporation could, for example, properly deny a shareholder access to corporate records to prevent harassment of shareholders or some type of other abuse of process. And so we're going to talk about shareholder derivative litigation in the next segment. And I'll touch a little bit more on that. And another right we should just touch on is your right to transfer your shares after your inspection rights and your dividend rights and your preemptive rights. You have a right to transfer your shares because these shares represent your ownership of the company, even though it is possessed in intangible form. You have a right to transfer your stock unless there are valid restrictions on transferability. There are a variety of these types of restrictions that are valid. For example, if stock that's obtained in the course of employment might be restricted for a certain number of period of vesting. So my stock might vest over 5 years, 20% per year, right? You give me 100 shares, I get, 20 shares vested per year, right? And at the point that that stock becomes vested, then I can, if it is tradable, I can trade that stock freely. That is the there are other types of restrictions that might exist. For example, in a very closely held corporation, there may be limitations on the manner in which one transfers stock because they don't want to just invite in strangers into a closely held corporation. You might be required to sell that stock back to the company before offering it to anyone else. At the time that the company is notified of a proper transfer, it has to make a new entry in its books so that that intangible right transfers from the person who was previously the shareholder to the new shareholder. But until that happens, even if cash has changed hands, the actual rights will reside with the holder of record. All right, thank you for your attention to this segment. We're going to move into shareholder derivative lawsuits in the next. Thank you guys, and respond to the prompt below. Take care.